So a state's outright ban on concealed carry has once again been struck down, but now the state is trying to defend it at multiple levels, including in front of the Supreme Court. Now, before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. They have multiple different tiers of boxes that you can get. I like the premium box because I think you get a lot of value in that box. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans in the state of New York have once again been ruled on, and now the state's outright ban on concealed carry has been struck down by once again a new court. You may recall that recently the Supreme Court issued an 8-1 decision in a case called Rahimi, and then remanded another New York concealed carry ban case back down to the Second Circuit for a new decision in light of Rahimi. That case was Antonyuk, and it's now also back in front of the Supreme Court and heading to conference next week. However, there is another important concealed carry ban case that has also been ruled on by the lower court and is making its way through the process. The case we're going to be talking about in this video is called Christian versus James. The case was filed by FBC and SEF, and it challenges various aspects of the Concealed Carry Improvement Act. Now, what's important about this case is the district court has actually issued a motion for summary judgment in favor of the Pro 2A side, and they struck down the whole catch-all concealed carry ban that prevents carry at private locations without the consent of an owner. This decision strikes another major blow to the whole New York concealed carry ban, and this one is also very important because it's on the final merits. The other case, Antonyuk, is elevated to the Supreme Court, but that is still in an interlocutory posture. This case here is a final merits decision. Now, this issue of concealed carry in New York has been a very long battle that really should have ended after Bruen, but after Bruen struck down the prior May issue scheme in New York decided to pass a new law that really was worse than the one that existed prior. This law was challenged in multiple cases, and in those cases, there were preliminary injunctions that were requested and then granted by some of the lower courts. However, the state of New York then appealed those decisions up to the Second Circuit, who then granted some blanket stays on those preliminary injunctions. In response, there was that Antonyuk case, and in that GOA, Gun Owners of America actually sought emergency review from the Supreme Court. At that time, the Supreme Court did not want to get involved in that whole emergency application. They denied relief, but there were some orders there from Justice Alito that said that the Second Circuit had to move on those cases faster. The Second Circuit was then forced to actually review those on an expedited basis. They held hearings and then issued a new decision. In those cases, the Second Circuit actually found that Bruen was an exceptional case and that they did not have to apply Bruen in these challenges. Therefore, the Second Circuit vacated a lot of those district court preliminary injunctions. Now, in response to that, in the Antonyuk case, GOA then filed a second petition for emergency Supreme Court intervention. And although the Antonyuk case was still in an interlocutory posture, the Supreme Court did GVR, which means that they granted, vacated, and remanded the Antonyuk case back down to the Second Circuit in light of what they said in Rahimi. Originally, the Second Circuit was intending to have all of the consolidated CCIA cases reopened, including the Christian case, but ultimately they decided that they were only going to reconsider Antonyuk. And on re-review, the Second Circuit ruled the same way. Now, one important thing that did come out of that new decision from the Second Circuit is they disagreed with another circuit court, which was the Ninth Circuit. The Ninth Circuit recently upheld a Hawaii catch-all carry ban, finding that essentially since the state of Hawaii was okay with some of their statutes having multiple permissions where not only did you place a sign out, but you could also give oral consent to concealed carry on private property, the Ninth Circuit said that was allowed and did not violate the Second Amendment. In Antonyuk, the Second Circuit disagreed with the Ninth Circuit analysis, and the Second Circuit found that the outright carry ban was a violation of the Second Amendment, despite the fact that you could give multiple forms of consent. They just said an outright carry ban is unconstitutional. Now, that Antonyuk decision was also very good for this Christian case because the Christian case also is a challenge directly to the catch-all provisions in New York, where you can't conceal carry on private property without the consent of the owner. The district court in the Christian case, while all the other appeals were developing, was actually reviewing cross motions for summary judgment. What that means is that each side wanted the district court to rule on one or more aspects of the case on the final merits at the early stage of the case. And on review, the district court actually granted the pro-Second Amendment motion for summary judgment, so they sided with the pro-2A side, and they struck down the state's broad concealed carry ban. In that decision, Judge Sinatra stated that A newly enacted New York law makes it a felony for a concealed carry license holder to possess a firearm on all private property unless the relevant property holders actually permit such possession with a sign or by express consent. At least as to private property open to public, New York's restriction is unconstitutional, a result dictated by the teachings of the Supreme Court's recent cases addressing individual Americans' rights to keep and bear arms. Regulation in this area is permissible only if the government demonstrates that the new enactment is consistent with the nation's history and tradition. New York fails that test here. Indeed, property owners have the right to exclude, but the state may not unilaterally exercise that right and thereby interfere with the long-established Second Amendment rights of law-abiding citizens who seek to carry for self-defense on private property open to the public. So the court here relied on the Second Circuit's prior decision in Antioch, which also rejected the catch-all private property and public carry bans, so they relied heavily on what the Second Circuit already said in Antioch. The court stated that as the Second Circuit observed in Antioch, no matter how expansively we analogize, we do not see how a tradition of prohibiting illegal hunting on private lands supports prohibiting the lawful carriage of firearms for self-defense on private property open to public. Finally, the notion of a tradition is the opposite of one-offs, outliers, or novel enactments, and tradition requires continuity. So the state's justification for carry bans have been rejected once again, and carry bans have been struck down once again. Now, important for this case is that the Attorney General Letitia James has appealed that decision up to the Second Circuit, and she is seeking a reversal of what the lower court said. However, as we discussed, there is a big wrinkle with all this because the Second Circuit recently, like I said, ruled in Antioch that these types of catch-all carry bans are unconstitutional. In the appeal, FBC and SAF argue that the district court properly held that a no-carry default is unconstitutional. The restriction implicates the plain text of the Second Amendment by regulating where firearms may lawfully be carried, and it cannot be reconciled with the historical principles underlying the Second Amendment. This court already has held that the state is unlikely to be able to justify the law historically. The court should now hold that its prediction was correct. The state relies principally on the same hunting regulations that are relied on at the preliminary injunction stage, and it's even clearer now that those laws cannot justify New York's no-carry default. What the Attorney General Letitia James on appeal is arguing once again is that colonial-era hunting laws justify this catch-all carry ban in the state of New York. She believes that since there were some colonial-era laws that restricted people from hunting on someone else's private property without permission, the state of New York can now, in the modern era, outright restrict concealed carry in the entire state because they believe some, very limited hunting restrictions where you couldn't hunt on private property, that justifies this catch-all carry ban. The Second Circuit has already rejected this argument on a preliminary injunction review, and now what they're arguing is that they should also reject it on the final merits of the Christian case. Also, if the Supreme Court grants review to the Antioch case, it would also be pretty much game over for the state of New York on this issue. I would assume that the Christian case would be put on hold if Antioch is granted review. So right now, the state of New York and the Attorney General Letitia James are really backed into a corner. Their arguments have already been rejected on the preliminary injunction stage. They were rejected on the final merits by the lower court, and now they're likely going to be rejected by the Second Circuit on the final merits. And you have the looming Supreme Court review of the Antioch case and the looming conference that's going to happen next week. So that's what's going on right now with the New York concealed carry ban case. A lot is going on, a lot of good signs that this is moving in the right direction, even if the Supreme Court denies review to the Antioch case because it's still in an interlocutory posture. You have this Christian case that's moving forward on the final merits in front of the Second Circuit, and the Second Circuit has already rejected the catch-all carry ban at the preliminary injunction stage, and they're likely going to do the same on the final merits. So as we get more information, as things develop, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and the station will be maintained by armed scholars.